Thank you. Some lunch too.
Mm-hmm.
Oh, it's Casey. Like not ready to get ready.
All right, we're gonna give it another minute or so just to make sure everyone's getting logged in from the webinar. If we have any other people join us live.
I'm gonna be crushing my apologize.
Yeah.
We should have gotten all software.
Yeah, right.
Great day for it.
What company are you guys from?
I'm with Image 360 and Crown Trophy
Okay.
over on Sawyer. Vehicle wrap, signage, graphics, awards, apparel,
Okay.
all the fun stuff that helps highlight your business. But yeah.
Okay.
I'm Terry from One Stop Service.
So we're doing a safety ladder. Make friends.
Yeah.
Manufacturing.
With Insight Eye Care.
Oh, you're right.
I was
say right down the road. I think I just stopped in your office the other day to grab some name tags.
Yeah, name tags.
Mhm.
Yeah. Pretty much. If you dream it, we'll figure out how to.
All right, we can go ahead and get started. So for those in the room, please feel free to grab lunch as you need it. Welcome to everyone online as well. Thank you for joining me in this session on HR law. This time last year, the federal government had changed a law regarding overtime pay for exempt and non-exempt employees. And we had sent out a blast at that time to all of our Kerber Rose clients, just informing them of the change. And within 2 weeks of that, I literally had probably 100 or 200 phone calls from various clients saying, what is this new law? And I had to explain, this is not a new law. There was just a slight modification at that time. And a lot of people didn't even realize that that was a law at the time. And so we thought this session would be really beneficial for our clients and for many businesses throughout the area, just to get the basics of what do you really need to do to make sure that you're at a compliant level so you don't get in trouble as employers. And then if it's anything beyond there, we're always here to help. So we'll give you enough to be dangerous. Don't pretend to know anything more than that if you don't, and always feel free to reach out. So again, my name is Jen Witt. I'm a human resources consultant here at Kerber Rose. I've been with the organization for about 1.5 years, just over. My prior experience, I have 20 years of human resources experience in various industries, various companies throughout Wisconsin. And right now I have the dream job of helping a variety of businesses with their HR needs. So anywhere from current clients that just have questions, I can assist with that. There's project work that we also do from the HR consulting standpoint, like if you need a handbook written or policies updated, compensation studies to know, what you should be paying employees, employee engagement surveys, a variety of project work we do. And then we're also an outsourced HR function as well. So those that have maybe a department of one, or you're the finance director and the HR person and the IT person, we can assist with that. So I have my contact information up here on the screen for those of you on the webinar. And we'll be sending this information out afterwards as well. And I'm gonna keep touching my laptop even though it's too different. So like I had mentioned, a lot of organizations in the area, whether small businesses or mid-sized businesses, you have to wear multiple hats. So maybe you're the only HR person, so you have to be the only knowledgeable person, or you're HR and you do a variety of other tasks, including, you know, maybe the janitor or the maintenance person as well. And so, you know, sometimes, you know, you think about HR being, okay, there's hiring, there's firing, and there's everything in between. And they're typically thought of as people issues, but then they could turn into legal issues if you don't do it right. And so we want to make sure that people, business leaders are avoiding those slight missteps to be able to focus on the stuff that's really going to matter within your organization. So just a high level, first off, we'll go through some of the laws that apply, when they start applying and what it protects. And then we're going to go through real life examples. So it's going to be an interactive Q&A where, you know, we'll talk about a scenario. What do you think is the right answer? And then we'll go through what the answer is and why that is. So from a federal standpoint, this is a very small list of the employment laws that kick in once you hire that first employee. These are probably the most important ones. There's plenty of others that are out there, but the ones that you really need to make sure that you're doing well are listed here from a federal level. Fair Labor Standards Act is that one I mentioned earlier that there was a slight modification last year that's going through some court stuff, and it got overturned. Some of it got overturned, but the law is still in place. And the Fair Labor Standards Act kicks in once you hire your first employee, and it means you cannot pay just a salary to an employee, meaning they're not eligible for overtime unless they meet certain qualifications. There's two sets of qualifications that they need. It's a salary threshold, and that's what was in the news last year, was what that salary threshold is. But there's also duties associated with the position that governs whether or not you can pay that person on a salary basis, or whether or not they're eligible for overtime pay. Immigration Reform and Control Act, hopefully everyone's doing this. This just says you have to make sure that everyone is eligible to work in the United States, fill out the I-9 information, and do the record keeping. Occupational Safety and Health Act, OSHA, starts at one employee as well, and basically means you're going to provide a safe workplace. It governs how you report incidents or accidents that happen, injuries, what postings that you have to have, and then what you have to do to ensure a safe workplace. Title VII of the Civil Rights Act, that kicks in once you have 15 plus employees. And that's the Discrimination Act. You cannot discriminate against an employee or an applicant or a person based on certain protected classes, such as gender, religion, race, ethnicity. There's a list of protected classes within Title VII that you cannot discriminate against those individuals for being of that protected class. Americans with disabilities, similar, cannot discriminate based on disability. That also kicks in at 15 employees. Age Discrimination in Employment Act, or ADEA, that is 20 plus employees. Once you hit the age of 40, you're a protected class. And then FMLA kicks in at 50 employees federally. This is the Family and Medical Leave Act. So if an employee or one of their family members has a serious health condition, or if they're having a child, you have to provide protected leave to that employee. It doesn't have to be paid, but there's job protection for taking that leave for either birth of child, birth placement, adoption of child, or serious health condition of that employee or one of their family members. Then Wisconsin likes to sprinkle some in as well. Some of them are add on to the federal, some of them are its own. So here's 5 of them that come to mind when I think of just the laws that we need to be aware of in employment from a Wisconsin. If you operate in other states, every state is unique. For example, Michigan just adopted a sick leave, paid sick leave. So I've been writing policies for employers on how to comply with sick leave in conjunction with their already offered PTO leave. Wisconsin specifically, there's the Wisconsin Fair Employment Act. This is going to be very similar to the Title VII Act, where you cannot discriminate based on protected class. But the Wisconsin one expands what that protected class is. Federal says, gender, age, ethnicity and race, religion. Wisconsin adds on marital status, off-duty use of lawful products. So if you say our employees are not allowed to smoke cigarettes, that's discrimination in Wisconsin's eyes because it's lawful use. And then the last one is arrest and conviction record. So arrest record, automatically you cannot discriminate based on somebody being arrested for a crime that hasn't gone through the due process. Conviction, they say it has to be substantially related to that job. And so we'll talk about some examples of what that would be. 1 day rest in 7 is another one. That means in 7 days, you have to allow your employees a full 24-hour period of off time. There's ways that employees can themselves can sign off on that. For example, when I was in manufacturing, sometimes we worked a ton of overtime, and it was like any volunteer that we could get to come in and work on Sundays, we'll take them because we're very far behind. And so they would have to sign off saying, I am giving up my rights to this 1 day in 7 in order to make sure that I can work as much overtime as I want. But employers cannot impose that on employees. Voting leave. Wisconsin allows for 3 hours of leave to go vote, whether or not you have the ability to do that before or after work. And you can't ask for proof that that's what they were actually doing. So that's one that's unique to Wisconsin. And then there's employment of minors. I'm not sure how many within this group have minors, but hopefully, you know about the work permits and the hours that they can work. That's unique to Wisconsin. Federal doesn't. Federal has some, but Wisconsin has its own. And then the last one, which is the most confusing, is the Wisconsin Family Medical Leave Act. That also is 50 employees. The definitions under Wisconsin's are a little bit confusing. So if you are an employer that has to administer family medical leave, sometimes you're trying to run them concurrently, or you have to, okay, they're not eligible under federal, but they may be under state. If they're only eligible under state, it's 6 weeks, not 12 weeks. So that one can get a little bit confusing if you are over 50 employees. But again, another one that you need to be aware of. So the top 5 mistakes that we have, these are probably what I spend the majority of my time answering or helping employers through. And so if you could take anything away from this webinar or this session, remember these 5 things, and don't do these 5 things. Everything else we can help you with too. The first one, misclassifying workers. So this goes back to the Fair Labor Standards Act as far as whether somebody can be exempt from employment or from overtime or can be paid a salary. It also talks about contractor versus employee. And it muddles that line between if you hire a temp worker or you hire somebody as a contractor, making sure that you're not blurring the lines of co-employment and misclassifying that person as a contractor. So let's say I hire somebody through a temp agency or a contractor, and I'm telling them when they need to be at work, what tools, I'm providing all the tools that they have to use. I have a lot of influence over how, when, where they do their work. They could actually they should be considered an employee And then you're liable for all of those, you know, work comp and unemployment insurance and all of the things involved in employee relationships. Overtime rules, same thing. Not only just calling somebody a salaried and not paying them overtime for over 40 hours worked. I've also ran into situations where a business has several locations and there's different ID numbers associated, different entities associated with those locations. Well, one person works at one store and then they work at a different store. Do I have to pay them overtime? And the answer is yes, even though, you know, on paper, they might be considered two employers because they're the one owner, and they share operations staff, then you might be subjected to overtime rules in that instance. Not documenting performance issues. I know performance discussions can be very awkward conversation to have, and it's not a fun one. Nobody enjoys having these conversations trying to correct somebody's behavior. But a lot of times people are quick to go to the termination route for performance issues when they have not documented past issues. And so while it can be time consuming to document everything that has happened, and write down the situation, the conversations you've had, it actually helps you avoid litigation in the future. Poor hiring or interview practices. This is a large one too, that may eventually lead to performance discussions and terminations. It could just lead to problems. It could lead to discrimination cases too. And so if you're not being consistent in your interview practices, if you're screening candidates in a certain way that could be discriminatory, then you can also get into some issues. And then termination without process or documentation. So just jumping to a termination without having those conversations. So that's about the top, usually the majority of the conversations I'm having with employers that are having troubles. All right, so we're going to get into a Q&A, and we're going to give you a scenario and see what you think the answer is. So anyone on the webinar, just feel free. I won't be able to see like hands raised. We'll kind of look at the chat. If you want to enter it into the chat, or feel free to speak, take yourself off mute and speak, or anyone in the room, if you have the answer, let's walk through these scenarios. And unfortunately, these are all real life ones that I've had to help people through. So you're probably thinking, why would you even be talking about this? But unfortunately, I'm trying to give you real life examples of what you might encounter. So let's start off easy, the hiring process. What can or can't I ask in an interview?
This is great because I have 2 interviews this afternoon.
I just got done doing interviews.
Okay.
It was my first time ever, like, so just, yeah, sure.
So I know you can't ask like super personal questions, right? Like I can't ask like how old you are and
Are you married?
yeah, do you have children?
Yeah.
Mhm. So then I was asking questions like, at your previous job, did you ever like experience a tough challenge you had to overcome, like focusing more on performance and decision making?
Yeah.
I was lucky enough to get a short list of some questions that other like people in my position had used before me. And one that I thought was kind of good was like, how do you handle constructive criticism? Because I think like, yeah, I don't know. Everyone kind of answers it the same, but you know,
So
idea. Yeah, yeah. I love constructive criticism.
Yeah.
Yeah, basically anything in your Title VII, your ADA, you can't ask. So if it has anything to do with that, you can't touch it. But there are some managers, especially if you're working with other people, they will try to use certain questions that aren't necessarily specifically asking, but they're in a roundabout way trying to find out how old someone is or how, you know, they're almost trying to find like a backdoor loophole. So you want to make sure that you're kind of staying away from that as well. Because there are some people that get smart with it and really wordsmith it.
Like asking if you graduated from college
Correct.
compared to what year did you graduate from college?
Correct.
Right, or even can you walk me through a brief overview of your employment history versus like dates and times of when you, more specific, I guess, so
Right.
is that
Yeah. I've learned in my past, I have about 12 years of recruiting experience. And so there's been some hiring managers that are like really good with wordsmithing and they really try to,
yeah.
I'm trying to think of what, it's not necessarily a personal question, but they're asking,
It's leading.
it's leading to see if they're married or to see if they have kids or basically kind of having that culture of like, oh, what do you like to do on your free time? Or do this? Because a lot of people try to use that as like I hang out with my family and I have 2 kids and we like to go do this, we like to go do that. That can get you in trouble at certain times, depending on how it's worded and used.
So say I had a gentleman when we phone screened who was just like, well, I'm 61. And I'm like, okay, like, great. Like, I didn't ask you, but you know, then you feel like, what am I supposed to do with this information? Like, you're not supposed to tell me that.
Right.
Obviously, if they just like divulge it to you, you're like, great, thanks.
Lauren, is there anything in the chat or anyone online want to chime in?
I don't see any questions at this time, but if any pop in, I will definitely let you know.
Thank you. Oops. All right, so you can ask job-specific questions that focus on skills, experiences, and behaviors. Avoid asking anything that is a protected class, such as age, marital status, religion. And that's the thing, even if you don't ask the question, if somebody's trying to, well, I'm following the rules because I'm not specifically asking, but I'm getting the answer. Once you know that answer, then that applicant can say you discriminated against me based on that answer. And so, you know, I've certainly had it in interviews where I'm like, okay, I'm just gonna ask, you know, please don't share any personal information with me. Like I want to keep it job related. Keep it to the knowledge, skills, and abilities of the job. Culture fit can also be a tricky one too, because while culture fit is great, you know, you want to have people that you know, gel with and that get along with each other. Sometimes you're only hiring like people then, and you don't get that diversity of ideas. So keep it to the knowledge, skills, and abilities of the applicant. And then you can always get into culture fit at a later date. All right, found my candidate. Can I run a background check on them?
Yes.
With permission.
With permission?
Yes.
Okay.
With permission.
What can I get on that person?
Oh. We run them for a AAA. Any applicant pretty much. I mean, I'll see cap myself and then we cannot hire someone who has a felony because AAA, if they're towing, because AAA will not accept it. Sure. It takes time. But ask for permission and then run the background check,
Okay.
which is your company.
Is it post offer? After you've offered the
No, because
candidate?
they have to be able to pass.
Okay.
For us to hire a tow truck driver, but
No.
it's a background check for the company that AAA
Okay,
contracts with.
okay.
I think I changed my answer. I have not had to do this yet, but I'm trying to remember if I've ever had, and I did, I think after you've offered them the position.
After,
But,
yep,
yeah.
okay.
This is not my answer.
Anyone online want to chime in? All right. So yes, you can. You need permission. And the Fair Credit Reporting Act requires, that you get permission and it's post-offer, pre-employment. So the Fair Credit Reporting Act is one of them that governs, what you can and cannot do from even though it says credit, even if you're not running credit on that person, any type of background check has to follow those guidelines. And so if somebody does not pass the background check, then you have to send them an adverse action notification saying, I'm going to rescind this job offer unless you clear these things up. They have so many days to clear it up just in case something was out there that shouldn't have been, and then you can formally rescind that job offer. I would also advise not to use something like CCAP. CCAP, it can be very unreliable. I would go through like a reputable firm that actually specializes in background checks because they're pulling that social security number to know where has this person lived. CCAP is only Wisconsin. Also, they're dealing directly with the courthouses to find the information. The court systems are not required to provide their information to CCAP. And so it's not the most up to date. Something could have been dropped, something could be like not show up and it's pending. So I would strongly advise against using that as a resource, just because I've seen so many inaccuracies with it. So use a firm, and then that firm that does the background checks will actually walk you through that process and have their own forms for you to complete for the permission, for the authorization. And then if you do have to rescind that job offer, doing those appropriate timelines under the Fair Credit Reporting Act.
I just use the CCAP just for my own, like, don't listen to that. No, because if I were hiring tow truck drivers, so if someone has a list of offenses like this, I know to kind of bypass that, you know.
Okay, and let's go back to that substantially job related too. So we talked about the Wisconsin Fair Employment Act, where you cannot discriminate based on somebody's arrest record. Or conviction unless it's substantially job related. So if, AAA says you cannot have a felony, or you have to have a valid driver's license. Obviously that's job related. If it's a disorderly conduct, maybe that's not substantially job related. One that sticks in my head and has for years, and it may have gone through a different judgment by now through the court system, but it's always stuck in my head. Was when I was going to school for human resources, there was a case against Sears, Roebuck and Company. Remember Sears? My age and myself. They did not hire somebody who would have been in the children's department because they had a sex offense against them with a minor. So they said that's substantially job related. The courts actually ruled in the applicant's favor because they said he would not have had a chance to do that. I would argue in dressing rooms, there's plenty of opportunity too. But they try to make sure that it is absolutely substantially job related. If there's a violence case against somebody, but it's domestic, they may rule, well, that's not in the workplace. So that's not substantially job related. When it gets tricky like that, I always seek legal advice to make sure that I'm not discriminating and I'm not going to get myself in trouble for not hiring that person unless I know it is substantially job related. All right, I'm checking references. Can I ask about somebody's absences and how often they called in sick?
I would have to say no.
I think you could ask them about, attendance, but you can't ask for the reason.
Right, that's what I would think, or I don't think you can necessarily ask like how many times did they call. Oh, I don't know. I haven't had, no problem.
Okay, anyone online want to answer this one?
I should, I don't know.
You reference
Review juice.
What's going on?
All right, this one can be a tricky one because you want to know if they're gonna show up to work. However, when you're asking them specifically about sick time, you know, it could lead into a disability standpoint. You know, obviously there's ways to ask them if, you know, they were reliable. But even that, like, if somebody had a disability and they missed work because of that, you know, the employer might say that they were not reliable. So
I had an example where, like I had someone who worked for us, was a good employee, left, and then she used me as a reference. And when I was giving a reference to her employer, they asked me specifically about her attendance and her sick time. And this was someone who did regularly miss time, but she was still a good employee. So my answer back to that person when I was giving the reference, because I didn't want to give her a bad reference, I said to that person that she followed all of our employment policies
Right.
for her absences.
perfect. Yep.
Without telling them that, oh my God, she was sick all the time. She had all kinds of leaves of absences. She used every minute of our paid sick leave,
Sure.
you know, which she did. And, you know, but I didn't
Right.
want to be that person. I don't, you know,
Right.
I don't want to harm someone's employability.
Right.
The only thing I just said was, I left it very generic as to she followed all of our employment policies and leave.
Yep.
She never, you know, she didn't get disciplined for excessive absences outside of our policies.
Yeah. Yeah. That's a great answer. I usually advise employers to have just a general rule that you will not give references to former or current employees because you don't want that liability coming back on you then.
Yeah.
And so having just a blanket policy to say, I will give you dates of employment and their job title, and that's about it.
That's typically what we do also. It's a rare occasion that I would get one, but.
Yeah.
Which I'm sorry.
And being consistent with it too, because if you're giving a good one for some and then not for others, you know, it's really important to be consistent with that too. All right, what do I have to put in an employee file for how long? Who can access it? Let's talk about employee files.
The I-9 has to be in there, or like the work verification information.
Okay.
I usually keep, yeah,
Yeah, like
I keep the W. Oh, I keep everything for, well, Tim still has stuff. I just pulled stuff out from literally like 1999. So, and maybe before, but at least 9 years is what we try to do. But I think 7 is standard. But for employee files, we always keep the W. You gotta keep the W-2, the I-9, the Wisconsin withholding, direct deposits, like info if they have it. And yeah.
Who has access to the records?
Myself.
Yep.
They locked up?
How many years does it you have to keep? Isn't it kind of forever for employees?
So, no, I can also send out what the retention schedule is. Let's go through the answer. So, each employment document is a little bit different. So 9 years, 7 years usually is a good rule of thumb. Like I said, I'll send out the retention schedule that SHRM provides. SHRM is the Society for Human Resources Management. And they have a really good document to say if it's payroll records, keep this long. If it's I-9, keep this long. If it's whatever. And so most employers just decide to keep the entire file until the very last date of that instead of, oh, I'm going to purge this document in 3 years and this document in 7 years. It's best to have them separated too. So like a lot of employers I see will have current employees in one stack and past employees by year of termination, because it's so many years after termination, so then they can just purge that whole year at one time. I-9s need to be kept separately. They cannot be in the personnel file. Also medical records. So if you're doing examinations, even if they're just bringing in a doctor's note to say I was sick yesterday, needs to be kept in a separate file than the personnel file. So most often what I see here is that you have a personnel file, you have an employee medical file, and then you have all of your I-9s current in one folder or one binder, or, you know, they don't have to be separated by employee. Just you have them in one location. So then if, you know, you get audited, then you have that full year of past, you know, every termination by year or all current employees that you can just pull out. Here is the information on your I-9s. Questions at all on that one? All right. An employee worked more hours than that they were supposed to. Do I have to pay them?
Yeah.
Yes.
Everyone agree, yes?
Yeah.
Okay. That one's a good one. Yes. Employees need to be paid for all hours worked. If you have the expectation that you're not going to approve overtime or, you know, clocking in early, have a really good policy around that. It could become a disciplinary issue if they're working unauthorized overtime. So if, you know, you say nobody can work over 40 hours and somebody works 42, you know, it turns into that kind of, let's have a discussion about you're not following the rules. You still have to pay them though. All right, so we talked about this one a little bit already. So I'll just briefly go through this one because we kind of, you know, we touched on it. The difference between salary, which is exempt from overtime, or non-exempt, which they're paid on an hourly basis. They get overtime hours for anything over 40. And how do we know which classification to use? This one's complex, so we say call us if you need help in properly classifying an employee. So the first and foremost thing we look at are the duties first. And so there's 3 exemptions under the Fair Labor Standards Act: executive, administrative, and professional. And they have to meet certain duties in order to be one of those. For example, a teacher, an engineer, a doctor, something that you have to have like post-secondary education for, is typically exempt. Not always. Administrative is like your managers, or I'm sorry, executive is like your supervisors, your executive level. And then the administrative is more like the operational piece, like people that are directly involved in the operations of the business, are the 3 types of duties that we would look at. Administrative is probably the hardest one to really nail down. Then after the duties test is assessed, then they also have to have a minimum salary that they're paid in order to be exempt. I can't remember off the top of my head. I want to say it's like $40,000-ish right now. That is the one that was being changed last year and going back and forth of what that minimum salary needs to be in order to be exempt from overtime. Sorry, I have a tickle. All right, can we tell employees that they can't talk about pay with each other? Why not? I don't want my employees talking about pay with each other.
They have the right to share their own personal information as they kind of choose to.
Sure. So the right answer was no, you cannot tell them that they can't talk about it. So the National Labor Relations Act, a lot of people think this has to do with unions, but it goes union and non-union on this one. That employees have a concerted right to talk about working conditions. So they can tell each other, my boss is a jerk, this is how much I'm getting paid. You know, things that are general working conditions, the National Labor Relations Board has said employees can talk about it and employers can't stop you from talking about it. I do see this one a lot that, you know, employers try to say pay is confidential, but it's really violating the employee's rights to say that. My employee was working 6+ hours. Do I have to give them a break?
No.
No. You,
Well, not for salaried, right? Like we don't usually worry about that with salaried employees, but
I think it's eight, I think you have to give a 30-minute break after 8 hours.
Six.
I don't think you're required to look this one up.
I should definitely know this. So
I didn't know
They
you
do it all get it wrong, but.
anyone online wanna, we got 3 or 4 different answers in the room. Do I have to give employees breaks?
Yes, but.
The hours are different compared to kids to adults.
Mhm. I mean, I think it's required for minors, but it's not like legally required for adults.
I think, pretty sure it's required 8 hours or more, like in a 12-hour, because 12-hour shifts, you're allotted at least like 45 minutes or something in a 12-hour shift.
Sounds like we all need the answer.
You're right. There's actually no Wisconsin or federal law for adults that you have to provide a break. Obviously minors are different. Minors are 6 hours. In Wisconsin, the only law says that if you provide a break that's under 30 minutes, it has to be a paid break. If it's over 30 minutes, you can do an unpaid break. Obviously, that's not the right thing to do. And so that's why I put in here, you know, that my caveat, although not required, you should consider employee safety, fatigue, just the right thing to do. People need that mental break from their work to be completely relieved of duty. So if they are working 8 hours, 12 hours, please provide them a break.
No, we paid like the 30-minute lunch break, you know, it's we love to take breaks, so you take your smoke breaks and stuff.
Yep.
On the 30-minute lunch break, we pay for that. Can we require that they stay on the premises?
If they're being paid, yes.
Okay, but
Yeah, and
not if they're unpaid.
if they're unpaid, you can have, you know, whatever rule that you want to have. If it's paid break, it's definitely recommended that they stay on because they're still on the clock. And if they get into an accident, what happens with work comp or, you know, your liability there. So I always tell people if you're doing a paid break, make sure that they stay on the premises.
Okay.
Jen, we did have one response in the chat. Someone had said, I think they get 15 minutes for 6 or more hours, but that could be union mandated from their experience.
Yes, absolutely. A union contract is going to typically be a lot more strict than what I'm sharing. Every union contract is different. So I agree, you know, if an employment contract or a union bargaining agreement, absolutely. So thank you for that participation. An employee breaks their company laptop. Can I deduct the replacement cost from their next paycheck?
No. Not unless they sign something. Each time they damage something, they have to sign something.
Can't charge them for like the equipment and yeah.
Yep, usually not. And so whether, you know, when it's tools and things like that, things that they need for their job. An employer is required to provide that to them. If there's neglect, obviously, again, that could be a disciplinary action, that they damaged company property. But generally you cannot deduct, anything from a paycheck. And then there's also certain rules around, making sure that they're still paid minimum wage in that paycheck, even if they are signing off that, like, let's say they have to reimburse the company something, think tuition, we'll use tuition reimbursement as an example. Most companies say, like, you have to stay with the company for a year, otherwise, and then they'll have them sign something that they can deduct it from your check. There's still minimum law or minimum wage laws that kick in that you can't take their entire check. Employee has a medical condition, they share that with you. Can you ask about the condition and request doctor's notes for your records?
Are we talking when they call in sick? Can you ask them? Excuse?
Either calling in sick or just sharing that, you know, they have this condition.
I would say when they call in sick, that you can ask them to go to the doctor or to bring a doctor's note.
Sure.
But I don't think you can specifically ask people about their condition.
Okay.
And I know the doctor's excuses that I do get for repeat offenders. They never tell you what it is.
Right, just
it's just a general they were seen in the office note. So.
free to come back to work on such and
Right.
such a date. Yep. Anyone else?
I don't think you can ask about their specific medical condition. It's only if to provide a return to work slip if it affects their job duties.
Correct. Yep.
That's what I would feel would be the only record you can request as a return to work slip.
Yep. Anyone have anything to share online? All right. Yes, you can ask if it's going to be job related. So, you know, if it impacts their ability to do their job, you can ask about it. Especially, you know, if you need to get into a Americans with Disabilities Act and you're talking about accommodations that you might need to make. When somebody's calling in, I generally wouldn't ask, oh, what do you got? You know, not about the condition, but you can certainly ask for a note that they are able to return to work. I generally advise not to ask for it if it's occasional, or even if it's, you know, if the company has a general rule, if you're out 3 or more days, you must have a doctor's excuse. I usually advise against things like that. The reason being, it's going to drive up your medical costs if they're going to the doctor for every little thing, if they're on your insurance. Plus, think about it from your own standpoint. You're sick day 1. Yeah, I'm probably contagious. I don't really want to come into work. I'm not feeling good. Maybe I'm not better by day 2. Maybe I'm not, you know, by day 3, I'm starting to feel okay, but I'm just going to give it one more day. How many of us go to the doctor automatically for 3 days? So, you know, trust your employees to make that decision if you're going to go to the doctor or not. You can certainly have a policy, like if you do go to the doctor, we'll excuse time off or only count that as 1 point under my attendance policy or things of that nature. But requiring a doctor's note, unless you worry they're not able to come back, like you want to make sure that they are able to come back and work their job. So let's say they tell you, I threw my back out yesterday, I can't even stand, you know, and it's multiple days in a row. You're probably going to want to make sure that they are able to safely return to work. Also, once it hits the 3 days, if you are an employer that falls under Family Medical Leave Act, they don't even have to ask for family medical leave before your duty to respond kicks in. So let's say somebody calls in sick for 3 or 4 days, they mention that they go to a doctor. Employers are actually, that have to do FMLA, are obligated to then tell the employee their rights under FMLA. That might trigger something in your head to know, oh my gosh, I might have to offer this person FMLA because they said 3 days, or they were off 3 days, plus they said something about a doctor. But also making sure you have your FMLA posters up in your break room or wherever you keep your employment posters, so then employees know their rights. That helps. But courts have ruled that an employer's obligation to share information about FMLA is at a higher standard than employees just automatically knowing that that's available.
Jen, we did get a question in the chat. This says, if someone has openly shared their health situation, is it okay to ask them how they are or how things are going?
Obviously, and thank you for that question. Obviously, from a caring standpoint, you're probably going to want to know. And so, being that empathetic, sympathetic person you are, you can generally ask those types of questions. But once it gets to be, something that is impacting their job, you're going to want to have a more interactive process of like, what kind of accommodations do you need in order for you to complete your job? And sometimes that is time off. The courts have ruled under Americans with Disabilities Act, even if allowing somebody more time off than what you normally would, that might be a reasonable accommodation for somebody. So yeah, I would say you can generally ask the type of question, how are you doing? More so from a sympathetic and empathetic standpoint. All right, employee complains about their manager's behavior. A week later, you decide you're going to cut their hours. Can you do this? Depends on what the reasoning is. Anyone else?
I would say that you can, as long as you don't use that for your excuse.
Anyone online? I didn't specifically write this answer. It says generally no, but I would agree in those situations, what we talked about. So can we use that as an excuse to cut their hours? No, that could be considered retaliation. If you have a business case that coincidentally it came up, making sure that you have the documentation to justify that position or that decision, and making sure it's completely separate from them complaining or blowing the whistle on their manager's behavior. Just use caution after an employee raises concerns to make sure that nothing that you're doing could be considered retaliation.
Jen, someone did comment online agreeing that they think no, because it does look like retaliation.
Perfect, good answer. All right, an employee puts in their notice, 2-week notice, can we let them go the same day?
I think you can in Wisconsin because we're a right to hire and fire state, I believe.
You can, but you might still be liable for
Unemployment.
if they file unemployment, they have the right to collect unemployment during that notice period.
For sure.
Anything else to add on this one? Right, yes, that is the correct answer. So generally, yes, you can let an employee go. They don't have to finish their notice period. You don't have to pay them for that notice period either. The law doesn't require you to do that. They would be considered under unemployment for an involuntary involuntary termination at that point during that, 2-week period or during that notice period. So they may be eligible for unemployment during that time. But I would advise having this as just a standard practice. There's a lot of companies that I hear about that employees know, they'll talk about it. If I put my notice in, my employer is just gonna walk me out that same day. So then where's the incentive for employees to give notice if you have that type of policy? Maybe it's a job that you do need to have some knowledge transfer, or they're working on a really hard project. That just encourages employees to quit without notice. So I wouldn't have a standalone practice that you do that in all cases. There may be certain people that have access to sensitive information, or they're going to be hostile during that 2-week period, or, certain cases where you may want to let somebody go during that notice period. But I would advise having a blanket policy that you're just automatically going to let somebody go during that period. If an employee leaves, do I have to pay out their vacation?
No.
No.
Yeah. Dang it, I think. I just said those too, but we're a little too generous sometimes, but I can't remember if you have to. I think yes, if they've worked so much because they've earned those, like they've earned that.
They've accrued.
Yeah. I would say.
I take that back. Legally, you're not required to get vacation. So if your policy is to not pay it out, so it's basically if you do it for one, you do it for all. If you don't do it, you just don't have to do it.
Right. Yes, I'd agree with that.
I've had to talk to you sometimes about that. No, to confirm I'm right.
Right.
Which I always found.
That's right.
Any other thoughts on that one?
There is one in the chat, Jen. This one says, if it was earned, I believe, yes, typically you want to have a policy on this.
And that is correct. Wisconsin or federally, there's no law that says you have to pay it out. But what Wisconsin does say is we'll abide by what your policy says. So if you can have a policy that says I'm not going to pay vacation out, and that is perfectly fine. But if it's void, then that's up to the courts to determine that. If somebody files suit, but if it's clearly in your policy that you will or will not pay it out, that is what the courts will rule. So if your policy isn't updated, I would suggest that you look through that to make sure that it has the correct language. What I've typically seen is either we're not going to pay anything out, or we'll pay out accrued but unused. Some employers decide if you've used more than what you've accrued at that point, you're required to pay it back, but that gets tricky in trying to get that back, because you can't always deduct it from their last paycheck if they don't have enough. And are you really going to go to like a small claim situation just to get that couple $100 back? Probably not.
So what about the use it, like we have the use it or lose it, and then I let them carry 1 week over?
Sure.
That's right.
Yeah, you can certainly do that. And I'm seeing more and more of that carryover up to a week. You have to use it within the first quarter of the year before you dip into your other stuff. I've seen various policies like that.
Okay. Yeah, I've been arguing that one a couple times too. Make sure.
Come on. There we go. All right, we're getting to termination. What do I need to do? I need to terminate this employee.
Ideally, you would have had already recorded instances on why you want to terminate this employee, ideally. And then documentation on the termination process a little bit, like what kind of why you're terminating this employee, and then them signing it ideally. That's kind of.
Anything to add?
Is Wisconsin an at-will employee state? So we don't need, you don't need like a reason to fire someone. There's
But
good
then
ways to
they
do it.
Right.
But I'm saying, like, I don't have to come up with this like laundry list of like, this is
But the hard part is then it's easier for them to claim some sort of discrimination because you
Okay.
don't have documentation of like, no, it's job related. It's very job related.
sure.
I said you have to notify them, so either in person or in writing.
Okay. Anything else? Anyone online? Want to add anything? All right, documentation. We talked about that earlier, making sure that you have documented conversations with that person. They knew the expectations, they knew the consequences should they not meet those expectations. Even dates, times that you had conversations. Sometimes when it gets to a litigation case, it's 6 months, 1 year, 2 years down the road. Are you going to remember all of those conversations that you had? And so if you're having performance or conduct issues with an employee, obviously that first time is probably not going to trigger anything for you to say, on this date, I talked to this employee. So the first time is, maybe you don't have that documented. But when it starts to get to a point where, okay, I'm going to have to start writing this person up because of this behavior or this performance issue, then I would recommend starting to write down dates, times you had, you corrected their behavior, and you get, maybe you're getting to a formal written document, whether it's a final warning or a written warning to improve somebody's behavior. If it's so egregious that you're going to go straight to a termination, like theft or employee fighting, obviously you're not going to have all of that documentation, but you're still going to want to make sure that you have it clear in your policy that that's a serious violation and that could lead straight to termination. So making sure your code of conduct is up to date on what's what is acceptable behavior, and what steps you're going to take from a disciplinary process. So whether it's, a 4-step process of a verbal, written, final written termination, there's a suspension in there, whatever your policy is, make sure that that's very clear. Making sure it says this is not an exhaustive list of things, well, I didn't technically punch them, I only slapped them. That's not in the policy. And then what things that could be, a statement to say things that are very serious in nature might lead straight, or you have the right to skip steps in that process, is a good way to say that in your policy. Don't rely on at will as, I've heard that a number of times where, a manager will tell me, well, I just want to fire this person. It's at will. I can do whatever you want. You could still get in trouble for that based on, protected class. I had one situation where, they came back and filed, an EEOC claim based on disability. We didn't even know that person had a disability, but they had made a comment to their manager once upon a time to say, something around those, the manager never brought it up to human resources or even thought twice of it. But it's very easy to file an EEOC claim or Equal Rights Division as the state of Wisconsin. In Wisconsin, it's very easy to file a claim. It's also very easy to appeal a claim. And so typically employees have 180 days to file a claim with the EEOC or the ERD. they send the employer, okay, here's the claim, you need to have a position statement by X date with all of the facts. So you write up, you know, you have to spend money on either a lawyer or spend time if you're doing it yourself to come up with this position statement. Send it back in. The adjudicator rules on what the outcome is, and they might say, nope, there's no cause here. So the employee then has so many days to appeal that decision, and it automatically goes to court hearing. So then you're spending all that money all over again to defend this. So making sure you have all of your documentation in place before that is so important. I would also say timeliness. That's another one that we've seen from quite a bit. Somebody was terminated, but it was really busy and I had to wait because, you know, all these projects needed to be done. It was, you know, I couldn't do it right then and there because I really needed them. Do we have to do it now? Well, if it's 3 weeks from now, a month from now, 2 months from now that you're finally getting to termination, was it really that much of an issue? Was it that bad of an issue that you could wait? And so courts have ruled too that, you know, if you're not terminating within a timely period of time, it must not have been that serious. Is there anything else?
Jen, we do have something in the chat.
Okay.
It says, is it appropriate to have the statement and policies of expectations to this policy must be approved by HR? Policies provide guidelines, but when dealing with people, not all events can be classified as, in quotes, the same situation. We are getting mixed feedback from legal support.
On that particular, I'm a little, I guess I'm not clear on what the ask is. So that was the statement in the handbook. And you're looking for guidance on whether or not that statement is acceptable to enforce the policies? Is that how I was hearing that correctly?
I think they're asking, is it appropriate to have the statement saying exceptions to this policy must be approved by HR? Like, would that be an acceptable way to phrase it?
I would caution about, I think maybe we need to talk about this offline so I can provide my contact information too to talk through the specific situation. You know, I'm thinking exceptions right away that could be discriminatory if you have exceptions. And so I would really want to understand the full policy before answering that. So I just noticed now I can't. Is it appropriate to have a statement? You're certainly going to want to have HR do that. So as I'm reading this now, not that, you know, a supervisor can make those exceptions. So yes, that part is perfectly acceptable. Events may be classified as the same situation. Not all, policies provide guidelines, but when dealing with people, not all events can be classified as the same situation. We're getting mixed feedback. Yes, I would agree with that as well. That not all events can be classified as the same situation. Policies try to be as black and white as possible, but unfortunately there's gray area too. And so it might be somebody, you know, they might be two totally different situations, but on paper they look the same. And there's other circumstances that you're going to want to consider. The example I'm thinking of is if you have two employees who do something, one has been there for 20 years and has an outstanding record. The other one, you know, maybe just started 6 months ago and that has had other issues. You know, obviously that's one of those types of situations that is not black and white. So I personally think exceptions to this policy, yes, should be approved by HR. Just the way it's worded might, need a little tweaking. So feel free to reach out to me afterwards and we can talk through that specific situation. All right, so that is the scenarios we have. Are there any other scenarios that come up that we should talk through? Like, can I do this? Can I do that? I've had this situation in the past. Is it a violation? Maybe they'll come up. I'll give another opportunity at the end for questions, or you can always feel free to reach out to me afterwards. But just steps to stay compliant. Make sure that your employee handbook is up to date. I always say having an outdated handbook is worse than not having one at all. So if you don't have a handbook, get one. We do have software here that we can create handbooks. It also gives us alerts of when something changes. So if there's a law update or even a best practice update, we have that capability. And I would look at it once a year. I know that seems excessive, but laws change very quickly. So even if it's just a brief look, commit to it every other year for, an in-depth look. But at once a year, just make sure that everything is staying compliant.
I have a question on that.
Yeah.
So as far as employee handbooks, there's always things that come up. And what are the requirements for giving the employee handbook to the employee when there's a change? Like whenever we typically have made little tiny minor changes, and then not necessarily done a whole give out to, because we're a small company, we only have 35 people.
Okay.
But when there's been a substantial change to the handbook, like we implemented a whole new attendance policy. So that's something that affects their employment.
Yep.
So then we did a rollout where we met with each person individually. We went through all the changes in the handbook. We made them sign off, and then whatever. Is that required every time you make a change to the handbook?
You alluded to it with
But we made
one of your
minor changes
statements with
before.
if it impacts the employee, then absolutely make sure that they notice that or know about the change. If it's if it's one word change, maybe that's not necessary. But if you're changing how you do something or how you're going to hold an employee accountable or how they're impacted by it, it doesn't necessarily need to be a full rollout of the entire handbook.
Or do you need to sign off?
Even just if it's something very small, it could simply be a notification. Like I've had it where this one little thing changed and we're going to roll it out to employees verbally. I'm just going to document it. Like we had a meeting on this such and such a date that all employees knew about it. We didn't require a sign off at that point from employees that they were aware of it. It was just, maybe it's a posting on the bulletin board, or maybe it's just an email or a meeting to discuss it.
So not every change.
Not every-
Like if you're changing your handbook annually, you wouldn't have to get a sign off every single year unless you had significant change.
Unless it's impacting the employee.
Like the condition of their employment. Because
Yeah.
after us talking now, I'm thinking about changing. We just had a big rollout of our handbook this summer, and it was several years that we made major changes. But now I'm thinking about changing how we do the vacation payout,
Okay.
because our handbook states right now that we will only pay out a percentage of your vacation based on the time of year you worked.
Yeah.
Something like that. Because we have people that have 5 weeks vacation, and if they quit in February, I don't want to pay them 5 weeks
Yeah.
vacation.
Prorate it, yeah.
But we've had a practice in the past of people who only have 1 or 2 days vacation and they quit, we paid it out.
Yeah.
But I would like to maybe put clarification in the handbook, because that's not necessarily a consistent practice where I've paid out vacation to this person and I've not paid it out to this person in 100% situation. I want to make a change that states we will pay out if you have 10 days or less, 100%. If you have 10 days or more, it's a percentage.
Sure.
I don't know. I'm thinking of a change in our handbook already. And I'm just wondering, you know, would that maybe require a sign off probably? Because that's a benefit.
Not even necessarily a sign off, but just some sort of notification. Whatever, you have manufacturing employees, I'm guessing they don't have email. So
But we have a new online system now. We use Bamboo HR.
Oh, yeah.
And that I've uploaded the handbook on, you know, so it's always available to them online.
Yeah.
And I could make some kind of notification that states there's been an update.
That would suffice.
But now with that,
I don't know.
we have about 4 people who go online and use the system and log in.
Yeah, we don't have a lot of participation.
Would that still count as a notification if we know that less than 25% of our,
Still do a handout.
25% of our people actually utilize the system the way they're supposed to? Because it's new for us, and so we're still trying to get people.
Different process.
Yeah, we're still trying to get people to understand that it's a benefit for them.
From a legal standpoint, it would probably suffice because you have told them this is how we're gonna communicate with you guys, and if you choose not to use it, that's your own problem. Is it the right thing to do? Obviously, from a change management standpoint, you have to do baby steps.
We have
a little bit.
We have like, out of say 25 people, there's like 2 that do not have an email. And that's a requirement for like using the system and logging in and making it whatever. And there's 2 people that do not have an but they don't use email. They don't have it.
Even if it's a supervisor saying this, you know, this changed, if they have like a stand-up meeting every so often.
But it's a pain to roll out and have a meeting and go over the handbook and get a sign off and whatever. But whenever someone files a claim, the first thing that someone wants to see evidence of is a sign off that they've received the handbook.
Yeah.
I was gonna ask if you have to, we're a really small company, and our handbook is fairly newish still within the last like few years, and we have not been requiring a signature. We have, like 10 employees, including the owner and myself, so pretty little, but should we be requiring?
I think so, yeah.
Especially from saved my butt many
Okay,
times.
Yeah.
We're little, but that doesn't mean things can't happen.
Especially from an unemployment standpoint, that is the very first thing that they'll ask is, what policy did they violate? Show me in your handbook. Show me proof that the employee received the handbook or the sign off. And, you know, while having access to it, you know, on a intranet site or, you know, however other way may suffice, the guarantee is going to be they signed off that they received it.
Sure. Okay. Thank you.
Offer letters and job descriptions. I know that job descriptions can be a pain. I just worked with a company that had like 700 different job titles. And we went through the exhaustive task of writing job descriptions for all of them, but it's important to make sure that you're setting clear expectations of what job duties fall under certain jobs. Offer letters too set terms and conditions of employment. It usually has the at-will statement in there. Policies and procedures that might not be in your handbook. You know, sometimes handbooks only just have the very short blurb of something, but there might be a huge policy or procedure that goes along with it. So making sure that those are all updated as well. If you have managers within your organization, anyone who supervises others, make sure they're trained on this stuff too. Because supervisors are also held liable. They are a representative of the company. So even if you don't know something, but a supervisor did, the company can still be held liable. And then know when to call in help. There's obviously a lot of resources out there. You have my contact information. If you run into a situation that you need help with, you know, we're here to help. Questions?
Is there an update to the Fair Standard Labor Act for 2026? Because when you guys sent out that change last year,
Yeah.
there was changes for 2025 and 2026 for like how it was going to increase, and then it got stalled, and then there was a minor change. Is there anything on the docket for 26?
I do not believe so. Salary threshold. I think they scrapped it altogether. There was specific increases each year after that. And they halted it, so no. And as things come up, well, like big changes like that, because that was a huge change. The prior one was like 35,000 and it was gonna go up to like $58,000 or something crazy. Big changes like that, you know, we'll send out notifications to our clients.
Yeah, I just know what the weekly amount was. It was
Yeah.
like 480, and then it was gonna go to 640.
Yeah.
Or whatever, and it ended up at like 700 or around that.
It,
Because it was gonna be like 1,000.
right, it was gonna be massive.
It was this like double jump.
Yeah, yeah. I would
Still
think of
under
it as
1,000.
yes. I don't know the exact number off the top of my head. But it did get reversed from the, I usually
Well,
look
they were
at it
so
from the
specific.
salary.
They were so specific about the amount and then the years it was going to,
Yeah.
like January 1st, 2025.
July 1st,
Yeah,
2025.
so it was like
And then
several days,
also
and then it was just
every
wiped out.
2 years or something like that. 2 or 3 years, yeah.
I had retired, so I wasn't around last year. Was it something I could worry about?
Is those the exempt overtime exemption?
The salary versus hourly.
Salary, whether or not you have to pay overtime to somebody, or if you can pay them a salary.
Oh, okay, no, I had a good report that before I left, I think.
Yeah.
It was coming out. And I pay overtime for anything over 40. so
Okay,
it's-
yeah,
And I used to be salaried and I met all the exemptions.
the duties,
But
yep.
now I'm already, so it's. Yeah, overtime. Partly retired.
Any other questions? Anyone online? Anyone in the room?
You excited for your interviews this afternoon now?
Pumped. All right.
Great.
All right, well, thank you very much for attending. We're gonna give you about 35 minutes back in your day. Please reach out with any questions. And I hope you enjoyed this. Thank you.
Thank you.
Yes, thank you. I think it's obviously good.